some of the colleagues.
Yes, I'll go ahead and take the one from Senator Ada before we broke for lunch. And the question that he was asking had to do with the fact that when there is that reprimand, then the report goes into the records, and that it stays there for 2 years. And the question was, why then will the commission expunge the records after that time, after 1 year of the warning, or the 2 years? This was one of the issues that was brought up by the union, and they had requested that language be there so that when it sits on the record and there's no occurrence, then it's a clean slate again thereafter. It's not that you're going to continue to build and build and build on it. They're always given that opportunity to start new. The appeals process, the second question was on the appeals process, and very similar to what Senator Nicholas was asking, is that the Educator Certification Commission is not a commission only to certify educators from the Guam Public Schools, but for all schools on islands, public and private. Therefore, the private schools do not have that appeal process to go to Civil Service Commission, but rather to the Superior Court. So on page 13, 7.02, that in the case of an appeal, GEC shall follow the procedures set forth in 5 GCA, Chapter 9, Article 2, related to the hearings, and that is the Superior Court. The other question which Senator Lim Tiaco had asked, and that was a code of ethics or an oath in which teachers then themselves, educators, and I don't mean just teachers, educators, because it includes guidance counselors, school administrators, librarians, of course, and classroom teachers that are all under this Commission for Educator Certification, because they're all certificated professionals. In the application process, and then also listed in the rules and regs, the very first one, which is on Bill 421 that we're updating, is that there is this code of ethics for educators, and it's in 5A, the GAR Education, Chapter 8, Guam Commission for Educator Certification. And it lists then in Section 8116 the Code of Ethics for Educators, and it has two principles, Principle 1 and Principle 2, and then it has a list in which all of the teachers then will read. Everyone's being certificated will have to read, and they will say at the bottom, I hereby certify that they have read then the Guam Code of Ethics for Educators, and they would sign it and date it. And then, of course, in addition, what they also try to do is that they would ask individual questions like a character testament questionnaire, in which the applicant then would answer yes or no, like have you ever left an educational or school-related employment voluntary or involuntary, and so forth. Have you ever been placed on leave for an alleged misconduct? Have you surrendered an educator certificate of any kind before its expiration? There's about 10 of those. And then it says here your signature and date. And then under penalty of false swearing, I declare that the information in this application is true, correct, and complete. Providing false information is grounds for GCEC to deny my application or revoke my educator certificate. I also grant GCEC permission to check civil and criminal records to verify any statements made on this application, and then again the applicant will sign. So there are these in the code as it is under the rules and regs, but not necessarily a part of this packet. So I hope I was able to answer then 3 of the members' questions.
Any further comments on the main motion? Any other senator wish to be heard? Hearing none, Madam Speaker, do you wish to close?
Mr. Speaker, thank you very much, and I thank my colleagues. Being an educator myself, and all educators do, is we take our responsibility, to heart. It's a major responsibility when you're dealing with, children. I used to always think that, yes, we're doctors and nurses, medical professionals. They can go in and take care of the body. But the one thing that is so impactful that can affect a child's life forever and their future is how then we as educators, work with them and teach them and nurture them and mentor, their minds. And that to me is a far more impactful thing that any one individual can ever impart or do for another individual. Because physically you can fix the bones, the sores and all that, and you can fix the wound. But it's very difficult to do that when it comes to the teaching of the minds of our children. And I know that everyone in here who is a parent or who has a niece or a nephew, want the best, of course. And I highly regard educators, just as I do with medical professionals as well. And I think it is so important that we continue to protect our children and that we ourselves as educators be that role model for school children. And I just ask my colleagues for your favorable consideration. And so with my motion is to place then Bill 420 in the third reading file. Thank you very much, Mr. Speaker.
Any objection? Senator Munya Barnes, Bill 428.
Mr. Speaker, and I'd like to move Bill 428-32 COR to the third reading, and if I can briefly speak on it.
Any objection?
Mr. Speaker, Bill 428-32 COR is an act to add subsection F to Section 8121 of Article 1, Chapter 8, Title 4 of the Guam Code annotated, and it's relative, Mr. Speaker, to establishing parity in the retirement annuity of the Attorney General of Guam. And again, Mr. Speaker, real short, it just says that the Office of the Attorney General, who is retiring from Gov Guam and is receiving benefits, shall not forfeit that annuity during period of an elected office. And I just, as it relates to the existing statute, Mr. Speaker, I just want to note that this is the same for all the judge and justices designated or assigned, and to all the elected positions. So I just want to include this, and I hope that my constituents would support this effort in providing parity to the Attorney General of Guam. Thank you.
Thank you. Any other senator wish to be heard on the bill? Senator Yamashita.
Thank you very much, Mr. Speaker. Mr. Speaker, I have 3 amendments that I hope are on desk by now. Sorry, I thought they were already on the desk. But in line of the intent of the mover of this measure to establish parity in the retirement annuity of the Attorney General of Guam, I'm making an effort to extend that parity notion from the retirement also to the compensation of the public auditor. I know there's been conversations the last 2 years or so, and sorry? I'm sorry? So, yes, no, but the compensation, there's been a conversation piece about the compensation of the public auditor, and there's been a conversation about there has been no study to say what she should earn, and that the that there has been a misalignment of wages to positions or lack of competitive wages in the marketplace. Typically, employees aspiring to advance in their career path as a government auditor should strive to move from the functional agencies to the OPA, the audit oversight of the entire government of Guam. And under the purview DOA, HR, OPA is unable to compete with autonomous entities, the federal government, the private sector, which have greater personal flexibility. And the recent 2014 Hayes study still does not make OPA competitive. And this has posed challenges for OPA to retain staff. The office currently has 2 audit supervisors who have 10 years of experience with OPA, while the average audit experience of the remaining 10 staff auditors is less than 2 years each. An updated compensation plan would assist the OPA in retaining its current staff. I'm reading bullets, Madam Speaker, that addresses to make the case of why I am in your bill talking about parity for the annuities, and I'm talking, this for me is germane because it addresses parity as far as compensation goes. And further, the current positions within GPA do not match those of a GovGuam auditor. GovGuam auditors conduct limited scope internal audits within the organization which they are employed. The public auditor and her staff perform a variety of audits, reviews, analysis, and evaluations of government programs and activities which may directly or indirectly support the legislature. Because OPA's staff work is multifunctional and quasi-judicial, it is difficult to assign an appropriate professional title to the role. Most state audit offices distinguish between and separate the work of the financial auditors from the audits of performance auditors. These audits and correspondingly the auditors are not necessarily functionally interchangeable, and each requires different education and training. Because of the lack of competitive pay for professionals at OPA, even loyal and dedicated employees at the agency cannot justify remaining with the organization when offered other employment opportunities which pay that is much higher than the current rates of the OPA employees, coupled with less responsibility. Over the years, the legislature significantly increased the responsibilities and work of the public auditor by assigning to the office the administrative adjudication process for recurrent appeals and mandating certain audits by statute. The first elected Attorney General took office in January 2003 with a salary of $90,000 based on 5 GCA subsection 3016, that his salary would be based on 90% of the Superior Court's judge's salary. And over the past decade, the Superior Court judge's salary has increased and is currently at $121,664. Accordingly, the elected AG salary has risen from $90,000 to $109,000 during this period. However, the public auditor and AG are both highly accountable to the people of Guam and are of equal value to the people. And so what has happened is, it's been stated over and over again that there has been no study that addresses the OPA's pay structure. And so what the Office of the Public Auditor has done is they issued for a study, and they had the leading edge consulting group do a study of the positions at OPA. And the following recommendations had been made. The core title for the job positions within OPA, which best reflects that role, is accountability auditor. Expansion of the number of job positions within OPA. OPA's wage structure should be updated in line with the new accountability auditor positions, that they should have hiring flexibility and autonomy, and the salary of a Superior Court judge with commensurate increases as a judge should be applied to the position of the elected public auditor. And so while the OPA has been told you should get a study done, that's what this current OPA did. So Madam Speaker, I have what should be now in everyone's desk 3 amendments, and I'd like to start with
You introduced the first one, right?
I'm going to...
Right, so we're going to take it one by one?
Okay, yes, please.
So
The first one is on page 3 of the bill.
right,
Madam Speaker.
yes. Do you have a point of
on a
information,
order.
Vice Speaker?
Yeah, I object to this one on germaneness. The salaries should be in 423, where we deal with the personnel of the Public Auditor's Office.
Oh,
This bill is a bill on the annuity of the elected Attorney General and the annuity of the Public Auditor. If she wants to muddy this one and have both of them go down, that's fine with me. But I'm just saying, I think we should do the annuity and the retirement issue separate from the personnel needs of the office. And there is a bill 423 on the personnel of the Public Auditor's Office, and she can try that in this one. If she puts this in this one, I cannot support it. So I'm objecting to it on germaneness because this one is annuity. It's the ability of the elected Attorney General and the elected public auditor to receive their annuity even as when they double
When they get
dip.
elected. Thank you, Mr. Vice Speaker. Senator Yamashita, do you?
And that's fine.
Okay.
I mean, if that
So-
makes more sense.
So then I need you
Thank
just to, based on that, withdraw your
I withdraw my
amendment.
Thank you.
On that motion, no objections, so ordered. So are there anyone else wishing to speak on 428? If not, Vice Speaker, can you just move that down to the voting file for me, please?
Move to place 423 in the voting file.
428.
428 in the voting file.
Without any objection, motion carried. Is Senator Mike Nicholas here for 429? Did this get moved down? We're gonna go ahead and take a minute recess. This legislature is back from recess. Senator Mike Nicholas, you're recognized on Bill 429-32 COR.
Thank you, Madam Speaker. I'd like to make a motion to place Bill 429 in the third reading file and to be afforded an opportunity to speak on the measure.
Yes, you may. Please proceed.
Thank you, Madam Speaker. Bill 429 is an act to authorize the appointment of deputies to enforce Guam's alcoholic beverage control laws by adding a new Article 5A to Chapter 3, Title 11 of the Guam Code annotated. Madam Speaker, over the course of the last term, I have observed closely the agency under my oversight, that is the Department of Revenue and Taxation, and their various divisions that are responsible for regulating and enforcing various laws throughout our island. One of these divisions is the Alcohol and Beverage Control Division, which is basically responsible for a variety of regulatory elements. They include enforcing our alcohol beverage control laws, tobacco laws, laws with respect to gaming machines and gaming in general. And this division, Mr. Speaker, only has 3 employees. That's it. For all of the alcohol establishments on the island, those selling on premises, off premises, the over 300 gaming devices that we have throughout the island, and so on and so forth. And so, Mr. Speaker, in order for us to get a better handle of the regulatory environment, we have several options. We can spend what is necessary to be spent in order to hire more full-time individuals in this division, or we can take a secondary route, which is in line with the route that's been taken in our police department, and that is to authorize a volunteer force that will augment the full-timers in the alcohol beverage control division. One of the things that makes going this route attractive is we, right now, for our 3 full-time employees in the division, they wear many hats. I mean, aside from going out and enforcing these laws, they're also the ones that process the applications for new establishments that need licenses. And so there is a full-time need to have employees there on the regular 8 to 5 schedules. But as many of us are aware, enforcing our alcohol laws goes all the way into 2 in the morning and a little bit thereafter for those on-premises establishments and for those establishments who sell alcohol that are still open at those hours, whether it's on-premises or off-premises. So there is a need for us to augment the full-time force who could handle and focus on the day-to-day operations of the division, while these auxiliary forces that come into play can go out and take care of the enforcement side of the house. And so what this bill will do is it will have the division basically bring up a volunteer force similar to our civilian volunteer police reservists in the Guam Police Department. They'll be responsible for enforcing the alcohol beverage control laws. They'll be required to take an oath of service. And the Alcohol Beverage Control Board will be able to promulgate the rules and regulations necessary to ensure that these individuals are properly trained, are properly supervised, and are properly supported by the department. One of the things that really attracts me about going this route, Mr. Speaker, is twofold. One, we provide an avenue to empower the members of our community who have a passion for making sure that these laws are enforced. It's one thing to be able to go out and hire a full-time employee who's going to make a career out of it. It's something else entirely to be able to empower our own citizens to take up the cause of enforcing or participating in the enforcement of an area that they're passionate about. And we do have a lot of members in our community who are passionate about making sure that these alcohol beverage control laws are being enforced. The second is that this is a way for us to get the enforcement up to par without spending a whole lot of money. And in so doing, we also create a self-regulatory environment almost, because when we have these deputies, the establishments that are being regulated will have less of an idea of exactly who these deputies are. Now, don't get me wrong, these deputies will be required to have the necessary identifications and so on and so forth, but they won't be as easily recognized as the 3 employees that we have currently in the department. So, for example, if one of these 3 employees walk into an establishment, all of a sudden they're recognized. The owners get on their best behavior, and that's a good thing in and of itself. But it will be an even better thing if our enforcers are not so easily recognized just by observation of the owners. So they'll never know, or they'll have a hard time really figuring out if the person in front of them is in fact, or maybe in fact, a deputy. So that in and of itself will create a chilling effect almost on the propensity for some owners of establishments to perhaps push the limits of the regulations, because they know that either one, the regulators are so few and far between that they're not likely to get inspected, or 2, even if they are, they're going to be able to recognize them coming a mile away, and they'll be able to get their act together before any kind of citations actually get handed down. So, Mr. Speaker, I look at this as a win-win for our community. It's cost-effective. It empowers our local people to be able to take up the cause, and it does so in a way that will almost create a self-regulatory environment for the entire industry. So I would like to ask my colleagues to kindly consider this. Before we get into the dialogue, though, Mr. Speaker, I know one of the concerns always is cost, and so in this bill, there is a provision here to create a stipend for this deputies program. However, this stipend hasn't been budgeted for in this current budget cycle. So I have one of 2 options. We can either delay the effective date of this act until the next fiscal year, or we can for now forego the stipend. I would like to see this act get moving, because if you reference subsection 35A09 rules and regulations, it does require these rules and regulations to be promulgated and implemented within 180 days. So perhaps we can forego the allowance for now, get these rules and regulations in place, and see if there is a good community response without the stipend and without the need for us to go into the need for us to factor in the budgetary impact. If in the event that after 180 days we promulgate these rules and regulations, we aren't seeing any volunteers because the stipend probably is a necessary incentive, we can still address that at the next budget cycle without having to wait a full 180 days for the rest of this bill to be implemented. So prior to discussion of the bill, I would like to proffer an amendment on page 5, striking lines 6 through 13, which would in effect take out the stipend provision of the bill. Madam Speaker.
On page 5,
yes,
line 6 to 13.
Yes.
Okay. So on the amendment, is there anyone who would like to speak on the amendment? Is there any objections to the amendment? Okay, so there being none, so ordered that, I didn't hit the gavel yet, so, okay, Senator Respicio.
Thank you very much, Madam Speaker. Madam Speaker, I certainly support what the mover of this bill is trying to do with respect to taking out the stipends because it's not budgeted, it hasn't been factored into the budget. But then if you read this bill in totality, which he's explained, the rules and regs still have to take into effect. So I imagine that once the department promulgates the rules and regs and the rules and regs are before the legislature, then both the executive branch and the legislature will have an opportunity to provide for the funding. So I don't know. I mean, my concern is that if you take the stipend out, one may read that in promulgating the rules and regs that the legislature is not going to provide for a stipend and that these individuals will be asked to do this on a strictly voluntary basis.
Okay, I understand, Senator. Senator Siniclas?
Okay, so I'm fine for that too. I can withdraw the amendment, and then if there is concern about that provision, then we can address it at that time. So I'll go ahead and withdraw it and turn the bill over for discussion.
Because otherwise I was going to save the rules and regs, then we can have it upon enactment of the rules and regs, then of course then the department will identify the funds. I mean,
sure.
that's
So I'll
way.
withdraw the amendment and put it
Okay,
with the
so
body.
there's a withdrawal of the amendment, no objection, so ordered. Is there anybody who would like an opportunity to speak on 429-30? Senator Yamashita, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, if the author would yield to a question, I'm curious, and I'm sure there's good reason, but I'm curious on page 3 that goes into page 4, the eligibility. It talks, the whole language and even the oath talks about not being an advocate of a change of by force or violence in the constitutional form of the government of the United States and the territory. I understand the felony and the crime involving moral or turpitude, but in the oath talks about the whole notion of force or violence. I'm wondering, is there something I'm missing here? Is there something that, is there a connection between ABC laws and rules and the Constitution of the United States? I'm just trying to understand why that's there.
Senator, do you yield to the question?
Sure, Madam Speaker. Again, we patterned this after the Civilian Volunteer Police Reserve enabling statute, and so we're just trying to mirror it as closely as possible because that has been effective in bringing up a reservist type of force. And so in seeking to do that in this more compact level with the ABC board, that we're just patterning it as closely as possible in areas that seem to be consistent. If that is a concern, though, that section A on page 4, we're open to any kind of changes that the speaker has in mind.
Okay, Senator, were you satisfied with the answer?
I thank you, and now that he said it, and he did say that at the opening, that makes sense. Because you want somebody who isn't going to be an authority to go and turn over an establishment just because they can, or just because that they want to. But they will do it for a good reason. So that makes sense. Thank you.
You're very welcome. On the motion, are there any others who would like to speak on Bill 429? Senator, would you like to close, or you want me to send it down? So on the motion then to send Bill 429 to third reading file without any objections, so ordered. Oh. This is not here. All right, so we will proceed on the category 2 of bills until such time that Senator Ada is ready with his bill. Will be bill number 345, and of course, primary author is Speaker Ben, former Speaker Ben Pangilinan, and I would recognize the Vice Speaker to present then Bill 345. Okay. Senator Mike Nicholas on Bill number 358.
Thank you, Madam Speaker. I'd like to make a motion to place Bill 358 on the third reading file and be afforded an opportunity to speak on the measure.
You may proceed.
Thank you, Madam Speaker. Bill 358 is an act to fund the restoration and redevelopment of the municipality of Hagatna by amending 21 GCA subsection 79501 and by adding a new item 13 to 5 GCA subsection 22425Q. Before I go into the purpose of the bill, Madam Speaker, just that everyone can be comfortable while they're listening, I'd like to immediately proffer an amendment on page 3, section 5, effective date, and change it from October 1st, 2014 to 2015. And the purpose of this amendment, Madam Speaker, is that we don't affect the current budget projections for the Territorial Educational Facilities Fund through this measure, and that way it can be properly factored into our FY 2016 budget.
On the amendment then to change the effective date to 2015, no objections, so ordered.
Thank you, Madam Speaker. Bill 358-32 will basically set aside or cause to be set aside the property taxes on the improvements on properties here in the municipality of Hagatna. And those taxes that will be set aside will then be expended for the purposes of Hagatna restoration. Just over lunch, Madam Speaker, I had the pleasure of going over to our fishermen's co-op. I like going over there every now and then to grab my lunch. And we chatted briefly about how the planned expansion or development of the co-op currently is funded to the amount of $2 million, but they're needing an extra $1.5 million to really get the project up to speed. This measure will provide the funding source not only for that project, but for the whole list of various projects that has been developed by the Hagatna Restoration Authority. They include various historical upgrades, various public easement and parking upgrades. They include some ambitious plans for additional renovations to the Plaza de España. All of these, Madam Speaker, are very good projects that we've been able to listen to over the course of the public hearings that make the future of the district, the capital district, very exciting. I know that there are members of this body who are also part of the actual planning organizations for the capital district. And so with all of this good work and all this anticipation, it is going to need a funding source. Now, by identifying these taxes and having them go to this cause, we not only create a recurring annual funding stream for Hagatna restoration, but the fact that it is recurring would allow for the authority to be able to go out and try and leverage this recurring revenue stream for even larger sums that can be reinvested into the projects. So this is basically a measure to take Hagatna property taxes on the improved properties here in the capital district and reinvest it into additional improvements in the capital district. And so what that does, Mr. Speaker, is it compounds the effect of the measure, because what happens is by taking property taxes on improvements and reinvesting it into the very community that's going to elevate once again the values of the surrounding properties, we will then thereafter increase the revenue streams because the property taxes will go up as the valuations increase. So ideally, this will become a cycle of investment, funding, and reinvestment that will just continue to help Hagatna thrive. And in so doing, not only will we have a capital district that we can all be proud of, but it will create more jobs. It will stimulate economic development. It will create more. It will improve the tax base, and all of those things can be redirected into the various priorities throughout this government, all by just investing more in the restoration and redevelopment of Hagatna. Now, I just wanted to touch on the subject of the original earmark for this funding stream. these property taxes for these improvements do go into the Territorial Educational Facilities Fund. And the Territorial Educational Facilities Fund does go to the improvements in our public school system. It's usually earmarked for capital improvements in our public school system. So what this bill does by changing the effective date to 2015 is we're not going to be affecting the budget that we passed just for this fiscal year just in October. We will be only impacting the budget going forward for FY 2016 because this act will be effective on October 1st. So come next fiscal year, what we can do is as the budget gets reformulated and as we're able to determine what our projections are, we can offset whatever amounts are being taken from TEFF for next fiscal year with additional taxes from other sources, such as the general fund, to augment whatever amounts are declining in the Territorial Educational Facilities Fund. Again, Mr. Speaker, this is a way for us to identify a recurring and trackable and dedicated funding source for Hagatna redevelopment and restoration. It'll create jobs. It'll increase the tax base. That increase in the tax base can go to education if there's any, if the adverse impact education is more than we would like it to be in fiscal year 2016. So I think that this will be a way for us to fund those projects. We always talk about trying to find out ways on how we can get the funding to what we need to fund. With the whole list of various projects that are identified and on the wish list for Hagatna, this will provide us with the recurring funding stream to be able to tackle them one at a time. So I ask my colleagues to please consider this, and I look forward to the dialogue on 358-32. Thank you, Mr. Speaker.
Thank you very much, Senator Nicholas. I understand the speaker wished to speak. Any other senator wish to be heard after the speaker?
Thank you very much.
Madam Speaker.
Thank you very much, Mr. Speaker. Mr. Speaker, I'm not arguing the fact, of course, about some of the benefits in terms of, at least when you look at the legislative findings and the intent of what, this bill intends to do. Nobody's going to argue that we want to redevelop, of course, our capital, the capital of Guam, and that no doubt for any kind of project, any type of development that is going to happen, will most definitely create jobs and provide jobs for our community and absolutely grow our tax base. The concern I have, of course, about this bill is that, and the author did allude to it, that the TEFF, the Territorial Education Facilities Fund, was designed and mandated by law that the real estate property tax revenues that we get from properties will then go into that special fund to be used specifically, yes, for the Department of Education. And it has remained, for the most part, with the Department of Education, our public school system. But just recently, this year, is that we have seen that we have included the Guam Community College to be able to take care of 2 of their buildings, and they just had a ribbon cutting ceremony last Friday that we missed. And in addition, the laboratory, the crime lab, also monies have gone to GCC to help them with those 3 facilities. The other is the University of Guam for the Student Center and for the engineering building. And the other bill again, and it's a major bill, and that will be then to build new or renovate, whatever the experts would decide, for Simon Sanchez High School. And then in addition, at the request, of course, of the superintendent, that we just only don't focus on one school at a time, but we try to take care of all of our schools. And there's that $100 million based on their reeval that then the government will be able to leverage, of course, to be able to go out and not just take care of Simon Sanchez High School, but to take care of all our schools, with the exception of those that are under a lease, right, a municipal lease. Currently, just this year, there definitely has been a shortage of monies, and so there's a shortfall to the Department of Education just from TEFF. It's going to be dwindled even a lot more when we consider, of course, and vote on another bill that we have on the floor that's now going to waive any type of real estate property taxes, and that's to the tune of 20 million. I mean, I didn't do the calculation, but that's definitely a calculation that we received. I think everyone has just about received that email or a text, and how it's going to then deplete the TFF. And so now to carve out just, of course, any type of real estate property taxes from our capital. And as you know, yes, in this area, a lot of it really, for the most part, are business, commercial lots. And yes, when you develop, there would be higher taxes to be paid for this. And that's a lot of money. So we're short now. We're going to be short 20 million from another bill. And how much more again when we just carve out the Hagåtña district of real estate property taxes that will not go to education. You know, many years ago, in terms in which I've been in this legislature, one of the things that we've always tried to do, and I read up on this, trying to find many alternative ways to be able to fund the Department of Education, not just operation, but most importantly, capital improvement projects, because we just never have enough money for that. And in the years that I've been here, and I'll tell you that, the very first one that was passed away even before I came in, but was built at the time I came in, was Southern High School, from monies that we were able to go out and take out of bonds. One school. Then later on, Tamuning Elementary School. The third school, JFK High School. And that's all from TFF. And you look at the span of years between that, you know, that I've been here, I can actually say with the exception of the new schools that are under municipal lease are coming out of compact impact monies. The rest of it is out of TFF. And here we have these other projects, and yet, you know, further depletion of TFF monies from, of course, real property taxes would just make it harder to be able to reach that goal. You know, building facilities is not easy, and I mean not easy in the sense about having to build it, but finding millions and millions of dollars. We're not talking about less than even $25 million almost per school. When we first started out, we thought we could build an elementary school for $3 million if we had the money and go right out and build it, and $5 million for middle school and $7 million for high school. That's not the case anymore. And we all know that even with the municipal lease, JFK now is one of our most expensive high school, and it even topped Southern High School. And we are paying for that every year through the TEFF monies. And I just, you know, I just can't see taking monies away from our school system. Like I said, we tried to find ways. We even thought about it. We actually passed legislation to use GRTs, 80% of the GRTs, to help support the Department of Education, and then we supplemented that with the general fund every budget year. But we knew that that wasn't enough, because when the monies again are not collected, then DOE would always be short. And we're constantly subjecting DOE, our public schools, to this, and not just DOE, but of course our other institutions. And I just don't want to see the department go through this again and again and again when we try to continuously, you know, take monies away. Now, it's a very creative way, I admit, in order to be able to provide some type of fundings to do the Hagåtña redevelopment, but it surely cannot be in the backs of our school facilities and our school children. Because I fear that already we are short this last fiscal year, and then with this other bill, we're going to be short another 20 million, and I don't even know what this is going to take, and you know, whether it's another 5 million, I don't know, and we surely can't afford to be able to underfund the department. And I know that we always say we want to fund it. We give what we can. They have the largest budget, I realize that. but that's because we have 31,000 school children, and we need to support them. So as much as I like the bill, I applaud the creativity in finding, other means, because, that's the one thing I try to do all the time, even though some of my colleagues may not be happy with some of the, ways and means and finding some type of funding to be able to fund our schools and projects. But I just cannot, I can't honestly support, the taking of TFF to be able from any one district per se, although it may be a small district, but it's definitely monies that could stay within our school system. Thank you very much, Mr. Speaker.
Thank you, Madam Speaker. Any other senator wish to be heard on the bill? Senator Limtiaco.
Thank you, Mr. Chair. And Mr. Chair, I just want to echo the same sentiments as the retiring speaker. And she had alluded to a bill that we're currently still working on, Bill 413, which is sort of the same basis for my objections to this bill right now. But I agree with her on the other sentiments that this bill is very creative. However, we cannot do it at the sake of taking away from the Territorial Educational Facilities Fund, the TEF. We every 2 years, everybody makes a commitment towards education. We've all seen the state of our current educational facilities. How many times do we have to revisit the fact that we're not doing enough to address those facilities, and yet this bill proposes to do just that, is to take those real estate taxes that would otherwise come from the reappraisals and redirect it to a worthy cause, but not as worthy as our children's education. And for that main reason, I agree with the retiring speaker that we cannot do it in spite of that. Or I shouldn't say in spite of that, but we cannot do it at the expense of our children's education. Thank you, Madam Speaker.
Welcome, Senator. On the motion, does anybody else would like to speak on it? Senator St. Nicholson to close.
Thank you, Madam Speaker. Madam Speaker, I will always be an incredible proponent of education. My grandfather was Director of Education 3 times. My parents are both retired teachers and school principals, and my wife is currently an administrator in the same Guam public school system. One of the things that we need to be honest about is the fact that the shortfalls to DOE over the last several fiscal years have been due in large part to the Territorial Educational Facilities Fund. It is one of the most unreliable funding sources that we have in this government, and we over and over again, every single fiscal year, put our school kids and our system at the mercy of this fund. In the last budget cycle, I attempted on multiple occasions to have the Department of Education fully funded from the general fund, which would be the most reliable source, because the general fund has all different funding streams going into it. You have gross receipts taxes, income taxes, withholding taxes, all different kinds of taxes going into the general fund. And if we fully fund education from the general fund, that will be the best thing that we can do for our kids. Get them out from underneath the Territorial Educational Facilities Fund, because that's the one fund that has been shortchanging them over all these fiscal years. In the last budget cycle that we had, I tried to make a big chunk of the Department of Revenue and Taxation get funded from the projections of the Territorial Educational Facilities Fund, because the Department of Revenue and Taxation is the one responsible for making sure the money comes into the TEFF every year. And over the last of how many fiscal years, it's been short. And so the whole logic behind that was make that be their budget so they can finally go out and make sure the monies are going to be there based on the projections that they're providing. Otherwise, they're the ones who are going to be short. So I would actually prefer going forward, and one of the things I'm going to be in discussions with the budget chairman going into our next budget cycle is the idea that we shouldn't be funding education at all from the TEFF or its respective funding streams. As a matter of fact, if we were to reorganize funding streams a little bit, we may see some interesting things happen. For example, By having the property taxes go into the restoration of Hagatnya, we'll see the compounding effect of Hagatnya redevelopment, increasing property values, and more money for redevelopment. And if this works out at just Hagatnya, we can then explore doing this throughout our island for all the respective municipalities. We can have a redevelopment authority in almost every village and have this particular property tax go into those various redevelopment authorities. Then all of a sudden, Chalampago will be able to have its own property taxes reinvested in improving Chalampago, in Alahan, Umatic, Jigul, Derido. All the villages will be able to have these kinds of redevelopment funds coming in from their own property taxes. And so with that, the people living in their village will be reinvesting in the improvements of their village. Now, can we do that and not shortchange education? Absolutely. And the way we do that is we reconfigure how the budget has dollars going into the various priorities. So instead of education currently being funded with the general fund and augmented by TEFF, we take that full dollar amount and make it funded by the general fund. And then we reorganize in other areas of the government so that instead of the municipal planning councils getting funded by the general fund, they get funded by the property taxes. And that's how we can work these things out, by having the funding streams dedicated directly to the sources that they are responsible for. So the purpose of the purpose of 358 is not to shortchange education for the sake of Hagatnya. That's why we actually push back the effective date till next fiscal year, so that we're not going to affect anything that's been budgeted for already. But that way, when we get to next fiscal year and we do talk about the budget, we can say, you know what, because Bill 358 became law, we're going to reduce DOE's reliance on the TEFF by, let's say, $1 million, or we're going to increase DOE's general fund appropriation by $1 million. So we would have refined the funding stream to DOE by giving them a funding source that has multiple streams coming into it with those various taxes versus this single source that has proven to be unreliable over so many fiscal years. And touching on Bill 413 a little bit, because it was mentioned in some of the testimonies that, we're going to shortchange education by $20 million with that provision. That is not accurate, Madam Speaker, because the way the budgets are projected is receivables that come into the government of Guam are not factored into the budget. So the budget for the Territorial Educational Facilities Fund does not include that $20 million. If that $20 million comes in, it's going to be a receivable that comes in, but it's not part of the projections, because the projections are not included the receivables are not included in the projection calculations. So every single dollar that we projected for the Territorial Educational Facilities Fund for fiscal year 2015 will be safe. This bill put it off with respect to Hagatnya until next fiscal year, and 413 and that $20 million that's potentially still outstanding will be neither here nor there, because it's not part of the projections at all. So as we go forward and try and figure out exactly how we're going to address a lot of the challenges that we're having on the property tax side of the house, again, I would like for the body to consider that Bill 358 is almost a pilot program, so to speak, of how we can begin looking at where our property taxes are going in a different light, and whether or not we really want to be funding our education system in an unreliable funding source that has been proven over the last several fiscal years, and instead move it more in the direction of having it fully funded from the general fund. I really think that fully funding education from the general fund is the way to go. Multiple streams of income to buttress the appropriation, and DOE is our biggest commitment in this government. It should have the most streams of income supporting the funding projections that we are allocating towards it. So I would like for everybody to consider Bill 358. I know it's a deviation from the norm, but I think that if we are diligent about it and open-minded about it and make sure that we follow through on it in the next budget cycle, we can do this and make sure that DOE is fully funded from an even more reliable funding source, that is the general fund. Thank you, Madam Speaker.
Welcome. On the motion to send 358-32 to the third reading file, hearing no objections, so ordered. Mr. Vice Speaker, are you ready for let's see which one, 418?
I believe it's 345.
Oh, wait.
Senator Ben's bill.
Oh, 345, I'm sorry, yes.
Yes, Madam Speaker, I'd like to move the Bill 345-32, COR, as amended by the Committee on Appropriations, Public Debt, Legal Affairs, Retirement, Public Parks, Recreation and Historic Preservation be placed in the second reading, and I'd ask for a short
Third reading.
opportunity to speak.
Third reading.
Third reading.
Okay, you may proceed.
Madam Speaker, as you know, our late colleague was very concerned about the fact that we in the government Guam have probably been more guilty of taking land from our people and not compensating them appropriately than the allegations that we make against the federal government. And in his years in the legislature has attempted every year to try to make sure that government land that is taken, condemned by the government for use for whatever purpose, is properly compensated to the landowners. In Bill 345, the author was very concerned about the fact that we needed to continue the expansion and upgrade of the Hagat-Umatek Highway. And the fact that in order to be able to do that, many parcels of land alongside the road were being utilized, taken, but not really condemned by the government, and therefore the owners have not been compensated for the use of the property that they lost. In Bill 345, the author tried to address the issues as it relates to just that portion of the highway, the Hagat-Umatek roadway. He's listed the landowners whose lands have been taken, some of the land, how big they were, how many square feet, how many square meters they were. And in this bill, there's to be 2 appraisers to review the land that's been taken, to appraise the land, and to give a value for it. And in this bill, the intent is to have the Department of Land Management in its inventory of government lands to exchange on a value for value, as per the appraisal done by these 2 appraisers, value for value exchange of the property that these landowners along the Hagat-Umatek Road have lost use of. And it's fairly extensive. It talks about the ways that you can have that the appraisal, and how there's to be a lottery to exchange for certain families, and it would be to be administered by the Department of Land Management and the mayor of Umatek, and that there's also to be $20,000 taken from the Land Survey Fund to pay for the appraisals that are going to be done as a result of this piece of legislation. And so, Madam Speaker, I'm hoping that this will be just the first of a series of pieces of legislation that over the next several years, we as the government of Guam will own up to our responsibility to make sure that the small people who have lost land as a result of road expansion get the same kind of treatment that big landowners get when large tracts are taken from them. Because percentage-wise, maybe the 200 square feet in front of someone's property is all of almost 30%, if not 40% of their entire land holdings. And maybe with some of the big landowners, dozens of hectares are just a small little portion of the land baroness's holdings. And so it's trying to address the fact that there are many, many families along the Hagat-Umatek Road whose land have been taken and who have not been compensated, that Bill 345 tries to address, and to try to do this as efficiently as possible by having appraisals done on the cost of the property taken, and that the exchange be value for value, not area for area, but value for value. And I'm hoping that my colleagues will assist in seeing to it that this last piece of legislation from our colleague gets passed through this legislature. Thank you, Madam Speaker.
You're welcome, Senator. On the motion, Senator Uggan, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I'd like to first of all recognize the efforts of the sponsor of the legislation. You know, what's very interesting is that there was a public hearing maybe about 5-6 months ago where a particular family was finally, a remedy was reached with regards to the government accessing and taking of their property. And $25,000 was the agreed amount that the family was willing to accept in exchange for that property. And that put a closure to that particular family's issue. Here we have another piece of legislation that would try to put a closure to private property that the government of Guam has gone into use for public benefit, but has yet to put a closure in terms of compensating the families appropriately. And I certainly hope that this legislation would realize that. But I'm standing here also just to recognize that Route 4, in which the Luzon landfill, with many of the trucks that take the trash throughout the entire island, many of these trucks traverse Route 4 going down to Malolo. The challenge with that particular roadway is that much of that roadway is presently under the title ownership of private landowners. And I bring this up, Madam Speaker, because that's another issue that this government really has to own up to, especially in light of the Luzon landfill now being the more or less interim trash receptacle and disposition for our entire island. We need to put a closure to that. We need to identify exactly what the parameters are, where the properties are, where private landowners were affected, and if the government can either exchange land as provided similar to this legislation or come to a resolution in compensating these landowners, I think we really need to realize a closure to that particular situation. And I say that because the mayor of Inalahan had a town hall meeting last week in which serious concerns were raised about repairing and upgrading and expanding that roadway going down to the Luzon landfill and all the way to the village of Inalahan. And one of the challenges highlighted in that situation was that federal funds are very restricted in being used for the repair and upgrade of that particular roadway, specifically because much of that roadway still is owned by private landowners. So we need to certainly look forward and continue our efforts in not only putting a resolution to this agadumatic area in which private landowners will be compensated by virtue of the government taking their properties or eventually taking their properties and using it for public access roadway, and applying that same concept to the other side of the island on Route 4 down to Luzon landfill, because the only way that is going to be upgraded, and unless the government of Guam can identify financial resources outside of the federal highway funds, then that's going to continue to pose a tremendous challenge. And I have to highlight, Madam Speaker, that you traverse that very same road I'm talking about several times every single week. So I want to just bring that to the attention of the body, and certainly hope that we can also look at addressing some of those concerns so that we can put a closure to those properties and eventually put it under the title ownership of the government of Guam, compensate the private landowners, and eventually work on expanding and improving that roadway. Thank you very much, Madam Speaker, and I stand in support of this measure.
You're welcome. On the motion? No one else? Vice Speaker, like to close? 3:45?
Just very briefly, Madam Speaker, as to what the retiring speaker referred to. That's the reason why I said this is probably going to be the first of a series of bills that we as legislators in the next legislature will have to address, because I think we have to at some point come to terms with the fact that though we may be, some of us may be critical of the taking that was done by the federal government, that our hands are not exactly clean with the government of Guam in trying to, when we take land. And yes, all of Route 4 needs to be addressed, and we'll have to, thankfully I don't have land next year. Whoever has land can try to tackle that one. I'm just trying to finish up what the good chairman left me in addressing this small section, the Hagat Umatak Road, and hopefully in the next legislature address Route 4 and the Litzoan Highway. Thank you very much, Madam Speaker, and I'd like to move this to the voting file.
Thank you, Mr. Vice Speaker. Imagine this island if, you're right, that all of our people are compensated for any of their land takings. We would make history in the world. So on the motion to send 345-32 to the third reading file without any objections, so ordered. Senator Respicio on bill number 400.
Thank you very much, Madam Speaker. Madam Speaker, I move that Bill 400-32 COR, an act to adopt the Uniform Enforcement of Foreign Judgments Act, UEFJA, and the Uniform Foreign Money Judgment Recognition Act, UFMJRA, be moved to the third reading file.
Would you like to speak on it?
Very, very briefly.
You may proceed.
Thank you, Madam Speaker and colleagues. The basic intent of the UEFJA is to give to holders of sister state or foreign judgments the same rights and remedies as the holder of a domestic judgment. Likewise, the purpose of the UFMJRA is to provide a uniform mechanism for the recognition of foreign country money judgments in the same manner as judgments of sister states. The UEFJA, Madam Speaker and colleagues, and the UFMJRA have been adopted by an overwhelming majority of jurisdictions, 47 states, the District of Columbia, and the CNMI, and the other states have similar statutes. And so basically my intent and reason to introduce this bill and to request the body's consideration is so that Guam updates its codes to follow along with what the other 47 jurisdictions, including the CNMI, has done. And so the current procedure to enforce judgments rendered in the other U.S. states and territories in Guam courts is an arduous process that places a burden on local businesses, while at the same time poses a disincentive to outside entities looking to do businesses on Guam. The UEFJA will streamline the process to enforce outside judgments on Guam, which will make Guam more attractive to investors in other states and territories who want to conduct business here, but are hesitant due to the possibility of protracted litigation to enforce a judgment obtained in another state. And so I've just read a statement provided by Attorney Cabot in support of the legislation. We also received other supportive testimony from members of our legal community, all of which has been appended to the committee report. And so, Madam Speaker, basically, if this bill passes and is signed into law, someone simply can just file with the courts a judgment, and that we would provide for reciprocity so that they won't have to go through the same process to which they secured the original judgment in that foreign jurisdictions. And so I ask for favorable consideration, and I thank our colleagues for the opportunity to have me discuss this bill.
You're welcome, Senator. On the motion, I have Senator Nicholas.
Thank you, Madam Speaker. I find this bill to be very interesting, and I certainly can support it. The one thing that I want to make sure of, though, is if we're going to allow foreign countries to render judgments and then to reach into Guam and take money with respect to the judgments they rendered, can we also make sure in this bill that if we have local judgments, that whatever jurisdiction we're allowing to reach in also is allowing us to reach out also? For example, let's say we have individuals who owe money at our hospital and they haven't paid, and we do the necessary proceedings to get them to court in order to get a judgment that they owe our hospital. Can we just make sure that there is a reciprocity arrangement. So we're not allowing foreign countries to reach in, and they're not also allowing us to reach out. So I guess I would first like to proffer a question to the author. I tried to see if it was written in here. I may have an amendment if it's not already, but I want to make sure that no foreign court is able to reach into our jurisdiction unless they are also allowing us to reach into theirs. And so is there any language in the existing bill that ensures that there's a quid pro quo?
Senator, do you yield to the question?
Yeah, thank you, Madam Speaker, and thank you, sir, because that's exactly what this bill would do. It provides for reciprocity, and so that without a uniform act, the person who obtains a valid judgment of a court in one state likely will have to relitigate the enforcement of that judgment in another state. So a state of affairs clearly violates the spirit of the full faith and credit and is a burden on those who have obtained a judgment in one state and who must take it to other states for enforcement for whatever reason. And so the basic premise behind this Uniform Enforcement of Foreign Judgment Acts permits enforcement of a judgment of another state upon the mere act of filing it in the office of a clerk of court. And so the act of filing the foreign judgment gives it the effect of being a judgment of the court to which it's filed. The process of enforcement then goes forward as if the judgment is a domestic one. And so when Guam implements this Uniform Enforcement of Foreign Judgment Act, then we can provide for the same reciprocity that's already recognized in the 47 states and the jurisdictions that I talked about.
Senator, may I ask you that the document you're reading, though, that you do provide a copy of that to the clerk so that be part of this journal. Thank you very much. Senator, was he able to answer your question?
To a point, Madam Speaker, but I guess I will just introduce my amendment just to be sure, because I read the same section, and the way I'm reading that is that there are 47 other states and territories within the U.S. that have these uniform procedures. But what I'm concerned about aren't those 47 states and territories. Those are all within the U.S. judicial system. What I'm concerned about are foreign countries. If a foreign country is able to effectuate a judgment in their foreign court and have that judgment upheld here on Guam with this bill, I just want to make sure that same foreign country is affording us the same consideration. That way, if we have a judgment that we render here in our courts, they're going to allow us to fully execute it as seamlessly as possible on their side. So I do have an amendment I would like to proffer on page 6. The amendment will be for section 4, Standards for Recognition of Foreign Country Judgment. It starts on page 5 and it continues on to page 6. And starting on page 5, it basically enumerates the standards for which a foreign country judgment will be applicable here to Guam. And so it reads here, starting on page 5, a court of the Territorial of Guam shall not recognize a foreign country judgment if any of the following apply. A, the judgment was rendered under a judicial system that does not provide impartial tribunals or procedures compatible with the requirements of due process of law. B, the court did not have personal jurisdiction over the defendant. C, the foreign court did not have jurisdiction of the matter. And I would like to proffer an amendment to add a D that would read, the foreign court does not recognize nor reciprocate similar judgments rendered by the courts of Guam.
Can you read that again? The foreign court?
The foreign court does not recognize nor reciprocate similar judgments rendered by the courts of Guam. And so by adding that language, we're basically saying, if you want us to recognize your judgments, you have to recognize ours. And that way, we're not going to be having any one-way streets here with them being able to reach in and enforce their judgments unless they're allowing us to do the same. And it's just to make sure that there's parity in the relationship between Guam and the foreign country that we're providing the accommodations to, that they're providing us with similar accommodations.
Can you read it one more time? I have the foreign court does not recognize or reciprocate.
Does not recognize nor reciprocate.
Or reciprocate similar judgments
rendered by the courts of Guam.
Rendered by the courts of Guam. On the amendment, is everyone able to follow on page 6, line right after line 5, but to add a new subsection D, and to add the foreign court does not recognize nor reciprocate similar judgments rendered by the courts of Guam. No objections? What, I want me to read it again? Okay, we're going to take a brief recess. The legislature's back in session. We took a brief recess so that the amendment can be written. So can you please make sure everyone has a copy? And I'm going to ask the mover of the amendment to once again then present this to our colleagues.
Thank you, Madam Speaker. Again, what this bill is going to do is going to allow foreign judgments in foreign courts to be able to reach into our jurisdiction and have their judgments enforced in our judicial system. And the amendment that I'm proffering is to ensure that if they're going to be able to reach into our jurisdiction, that same foreign entity is allowing us to reach out from our jurisdiction and into theirs. If you reference the findings and intent of the bill, particularly on page 2, lines 9 through 12, it reads, "Moreover, because many civil law countries condition recognition of money judgments from foreign courts upon reciprocity, codification of the UFMJRA, which is this, will make it more likely that judgments rendered in the territory of Guam will be recognized in a foreign country." That those two words, "more likely," indicate to me that there's a possibility that while we may be recognizing their foreign judgments, they might not necessarily be recognizing ours. And so in the interest of making sure that our judicial system is afforded the same respect that we're being asked to afford foreign jurisdictions, I've proffered an amendment on page 6 between lines 5 and 6, adding a new section D. And this new section D will read, "The foreign court does not recognize nor reciprocate similar judgments rendered by the courts of Guam." And that will be under the standards for recognition of a foreign country judgment. So if a foreign court does not recognize nor reciprocate our local court's judgments on similar grounds, then we're not going to recognize or reciprocate theirs. I mean, it's only fair because, for example, let's say we have, as I mentioned earlier, somebody who doesn't pay a bill here at the hospital, and we want to, file suit to recover those funds, and the foreign country that they're originally from says, and we filed to have that judgment awarded, and say, sorry, that they're our citizen, we're not going to take their money out of their account and give it to you. And then they want to come back and say, hey, but by the way, so-and-so owes this person money that they sued for in our home jurisdiction. Can you make sure that they get paid? There's no quid pro quo there. So this amendment will make sure that while we are opening the door in good faith to allow for these foreign country judgments to reach into our jurisdiction, they're not going to be able to do so unless they allow us to also reach into theirs. And so I'm just doing this as an interest of parity to have this new section D added. The foreign court does not recognize nor reciprocate similar judgments rendered by the courts of Guam. Madam Speaker.
On the amendment, Senator Respicio.
Thank you very much, Madam Speaker. Madam Speaker, I don't think the issue is about parity. I think the issue is what can we do to help those who are residents of Guam make sure that a judgment that is made in a foreign court have, by exercise of law, have it easy for that foreign judgment to be recognized locally without the individual having to petition the court and to have that case litigated here on Guam. So that's the whole intent. Again, I read from a document earlier that when a judgment is filed, if this were a matter of law and a function of law, all the individual has to do is go to the clerk of court and notify that the person subject to the judgment of that filing and any ordinary method of enforcement becomes available once notice is given. So you don't have to litigate the case entirely from a Guam court. So I rise to object to the amendment simply because the bill is not dealing with parity, it's more so dealing with reciprocity. If you're a resident of Guam and you have a judgment that's in your favor that was made in a foreign court, and this bill outlines all those definitions and requirements thereof, all you simply have to do is go file with the court, and the clerk of court will notify the person that there's been a judgment filed against him, and so that will have the full, that will speak to the full faith and credit clause as required for by the Constitution, and so I object to the amendment.
Is there anybody else who would like to speak on the amendment? There being none, Senator, you want to close on your amendment?
Yes, Madam Speaker. I don't view this in that manner at all. As a matter of fact, it's clearly stated here in subsection item B, the foreign court did not have personal jurisdiction over the defendant. So our citizens cannot go to a foreign court and have a foreign court render a judgment on their behalf and then come back here and have that judgment exercised. Our citizens will need to go to our court here locally. What this bill will do is it will allow for a foreign judgment to be rendered in a foreign country, and then for that court to be able to have that judgment enforced here on Guam. So for example, let's say somebody entered into a contract deal in a foreign country and they didn't pay the other person what they owed in that contract, and now that person who didn't make that payment is here for whatever reason. The court will be able to reach out to us, that foreign court will be able to reach out to us and say, collect from that person and make sure that it gets paid into the system, because that's a judgment that needs to get honored. And so what I'm saying is that if we're going to allow foreign courts to reach out into our jurisdiction to have their orders enforced, we need to, in the interest of reciprocity, make sure that our local courts, if we have similar judgments against somebody who, like I said, let's say somebody owes so much money to the hospital, or let's say somebody has a contract here on Guam that they did not fully honor, and they go off to a foreign country, and our local court says that person does owe X amount of dollars to this person because of the contract agreement that was violated. That other country, if they want us to enforce the law here, better be willing to enforce our law there with respect to the court judgments. And so all this amendment says is a court of the Territorial of Guam shall not recognize a foreign country judgment if the foreign court does not recognize nor reciprocate similar judgments rendered by the courts of Guam. Basically what we're saying is, if you want us to honor your judgments in your foreign jurisdiction here, you need to honor our judgments here as well. And why would we want someone to be able to force us to listen to what their rulings are and then they're not going to bother to pay any attention to what our rulings are? I mean, that's the basis of reciprocity. It's the same rules apply in both jurisdictions. And it's very, very important, Madam Speaker, because, let's say we have somebody who owes money and then they skip town and we're not able to go and collect. But then on the reverse side, somebody who owes money over there skips town over here and they're able to collect from the money here. I mean, we can basically see outflows of capital from our territory and not be able to have any kind of quid pro quo recoveries for any kind of violations of the same. So out of respect to our courts, in order to make sure they're being afforded the same level of respect that we're affording their sister courts in foreign countries, adding this one provision in here will ensure that those foreign countries are affording our court the same level of respect. And that's all that this amendment seeks to do. It's not going to derail the entire bill or anything like that. It's basically going to say that if the foreign court is going to render that judgment and it applies here, then that foreign country better be willing to honor our judgments as we render them here as well. So that's why I'm proffering the amendment, and I'm hoping that we can pass this. And this is really the only item of concern that I have with this bill. Thank you, Madam Speaker.
Point of order, Madam Speaker.
Please state your point of order.
Madam Speaker, what could I do procedurally to help the previous speaker, or to say that the comments expressed by the previous speaker are not really what the intent of the bill is, without having a point of personal privilege lodged against me or anyone in this body? I simply want to say that the idea of this bill, Madam Speaker and colleagues, is not to take something that happened on Guam and litigate it in Korea and then have a judgment made in Korea, and so for the Korean government or the government of Arizona or another state tell the government of Guam how that thing should have been enforced. These are judgments that are made outside of Guam, that's recognized that something happened outside of Guam, and all the individual has to do is file with the court and say that reciprocity applies here, and so you don't have to litigate that thing over and over. So it's not...
And you asked how we were going to be able to do it, and I think that you would have the opportunity to do that when you close. But for now, either that, I understand that, but what we're going to do, I mean, the other thing, of course, that could be done is, a recess to be able to have that dialogue between you and the mover of the amendment. Or the third option would be then to set it aside and then again continue the discussion. So what is the pleasure then of the author of this bill? Not listening. Okay, since we're having a sidebar, we're going to take a recess. The legislature is back in session. There is an objection to the amendment, so I'm going to have to call for the vote. Oh, those who are in favor of the San Nicolas amendment, which reads, "The foreign court does not recognize nor reciprocate similar judgments rendered by the courts of Guam," to be added to page 6 as a new subsection D. And since there's an objection, I'm going to ask that all in favor of the amendment, please raise your hand. Sorry, it failed to get the votes, only received 5 votes. Okay, Senator, you still have the floor, or that's it? So on the motion then to send Bill 400 to the third reading file, objections, so ordered. Senator Ada, we have a copy now of the other substituted bill on the floor. Do you want to proceed today?
Yes, Madam Speaker. I'd like to resume the discussion. When
Are you going to introduce this to have us accept this new bill? Because then we'll have to withdraw what we were discussing, and then you can make a motion to accept this and then place it.
yeah, I guess so then I would probably need to show this as and further substitute it on the floor star.
So this one we have doesn't
This
have a
has some
star.
amendment, no?
This is the first substitute.
Okay, so I'm fine then.
Okay, so on the motion then to withdraw the bill that we were discussing, which was as substituted by the author and further substituted by COR, that we're going to have to withdraw, and then you're going to have to make a motion to accept this that is further substituted by COR and further substituted on the floor.
Correct.
Okay, so
moved.
So the first motion then is there any objection then to withdraw the bill that we were discussing as substituted by the author and further substituted by COR? No objection? So ordered. Then the other motion that the senator wants is now to accept the bill as substituted by the author and as further substituted by COR and further substituted on the floor. To accept. Any objections? No objections, so ordered. And now, of course, the motion to place on third reading this new further substituted on the bill. And Senator, you would like to speak on it?
Yes,
You may
but
proceed.
Madam Speaker, could I ask for just a 1-minute recess?
Okay, I'm going to give you 59 seconds. The legislature is back in session. Senator Ada, you're recognized. You would like to speak on 224.
Yes, Madam Speaker.
Okay, you may proceed.
Madam Speaker, when yesterday when I first started speaking on Bill 224, I was trying to explain that Bill 224 focuses on the back end of the procurement process. And the back end is where your protests and legal remedies and whatnot are basically handled when a bidder deems that something was not done properly with the solicitation or with the award. And the underlying, I guess, thinking in the amendments that were made was, how do we expedite the process? And so revisions were made so that from the time that a bidder submits a protest to the agency or to GSA or to Public Works, that individual has, by law right now, 14 days to submit his protest. But the law does not basically provide a timeline as to when the government has to respond as to whether it accepts or rejects the protest. And if it does reject it, it just, fills out a pre-printed form and says accepted or rejected and leaves it at that. So now some of the changes that have been made basically is that now the government has a specific timeline to respond. And it must, and if it rejects or accepts, then it has to provide a written findings or decision which outlines clearly the reasons for its decision. If then the government rejects the protest, then the protester can appeal that to the Office of the Public Auditor. And again, they have 14 days to turn around and transmit that appeal. But now he's better armed because he at least has a reason from the government as to why the protest has been rejected. And so then he can take his protest up to the OPA. The OPA then goes through its process and reviews the protest and normally tries to expedite that review and tries to issue a decision as soon as possible. And then if the decision that comes out, the protester again is still not satisfied, then it is deemed that he has exhausted his administrative remedies and then can now appeal it to the Superior Court. And so the revisions that have been made makes it very clear that you've got to first exhaust all your administrative remedies. You go to the agency, you go to the OPA, and then after all that is exhausted, then you can appeal to the court. And then yesterday during the discussions, a question was asked, and there was concern about when we get to the court, we want to make sure that, yes, we want to expedite the process in the judicial system, but we also want to preserve the due process in order to protect the interests of the stakeholders. And so that's what took quite a bit of discussion yesterday and today to make sure that we fix that. And so basically, the compromise that was reached was that then when the appeal is elevated to the court, that then the protester shall submit that protest to the court in the form of an action, I guess, which for the lawyer talk, it basically asks for everything to be able to discover, to be able to bring and whatnot. But when he gets to the court and he gets to the judge's courtroom, then the judge can decide whether, okay, I've got enough information here, I'm just going to make it as a review, I'll see you, come back in 30 days and I'll give you my decision. In some cases, it may warrant a full-blown trial, and the judge can decide that. Whereas right now, basically when you go to Superior Court, at least according to the law, it has to be a civil action, and that gets to be a full-blown, drawn-out action over at the court. So I think that the revisions, the amendments that have been made addresses the concerns about how do we expedite the process in the court while at the same time preserving the due process that really the stakeholders are entitled to. Then there was another question about what do we do if the OPA must disqualify herself. And initially the amendment that was made was, okay, if the OPA disqualifies herself, then she'll pick her, then automatically either the next senior auditor or the most senior auditor in the office will then take over the functions of the OPA. That, of course, was found to be objectionable. So basically, the compromise was that, fine, then it's going to go, then it'll get elevated over to the Superior Court. But what's important is that when it goes to the court will basically treat it as a de novo action, and basically will take a look at everything from the start again. And so then that particular issue was addressed. And then finally there is of course in the procurement law the option to debar and suspend. And the way the bill was written was that anybody can petition, let's say GSA, and say, I want company X over there to be debarred, and for these following reasons. And so then the petitioned officer, GSA, the chief procurement officer, the DPW director, or the head of the agency must then, when he receives that petition, must conduct an investigation. But we've gone in, we've tightened it up so that first, that the petition officer must conduct an investigation. And if his investigation finds that there's really not sufficient information found to warrant going into a hearing for debarment or suspension, then he has to issue his decision as to what his findings are, and that can be deemed as a rejection. Then the petitioner can then use that as a basis to then elevate an appeal to the OPA. Similarly, if the petition officer in his investigation finds that that there is sufficient, that there may be sufficient, that there may in fact be a basis for a debarment or suspension, then he will proceed in conducting a hearing on the matter, and then to come out with a decision and issue that decision. And so, basically, I think Bill 224 has basically, addressed those obstacles in chapters 9 and 12 that has to do with legal and contractual remedies. And I believe that with all the vetting that has taken place between the Attorney General's office, between attorneys in the private sector, the OPA, GSA, I think there was adequate scrutiny of Bill 224, and I believe that we have a bill here that will help now expedite the legal and contractual remedies that are made available by the Guam procurement law. So at this time, Madam Speaker, I'll go ahead and take my seat, and if anybody has any questions, I certainly will try to answer it.
On the motion, is there anyone who would like an opportunity to speak on the motion? Good job, Senator. Okay, so there being none, would you like another opportunity to close?
Yes, Madam Speaker. Madam Speaker, I think I just, it indicated what it is that we've tried to accomplish in Bill 224, and basically to try and expedite the review process in resolving protests. I just want to say that Bill 224 is one of a series of bills that will be introduced. This just deals with the back end. Now we're going to need to introduce a bill that will address the solicitation procedures, the solicitation options that we have. But probably more important than a series of bills being introduced to update our procurement law is the fact that we need to professionalize the individuals who are actually assigned to carry out the procurement functions. And I think in that regard, certainly to the credit of Vice Speaker B.J. Cruz, through his introduction of a bill that has now been enacted as Public Law 32-131, now mandates that those who are carrying out the procurement functions must undergo training and must achieve certain levels of certification over a period of time. And that, I think, is very important. I also want to emphasize the fact that the formulation of this bill has taken well over a year. In fact, a year and a month to date. And it has had 2 public hearings. It has had 4 roundtable discussions. And it has been looked at every which way, I think, by various attorneys. And I tell you, it is not easy putting 13 attorneys around a table and trying to come up with one decision. And so luckily, in that case, I had to result on some of your own common sense, and I had to rely on legal counsel also to give some advice regarding, really how do you close the gap between all the varying ideas. I also want to express that I've had a lot of assistance from Attorney John Brown, and he has certainly been very helpful in helping me with this bill. Through the process, I've learned a lot about procurement. And maybe that's why I went ahead and volunteered to have oversight of procurement in the next legislature. But I look forward to the challenge, and I certainly want to express my appreciation to him and my appreciation to the Vice Speaker through his patience in holding roundtable after roundtable discussions. And I just urge my colleagues to favorably consider Bill 224 so that we can move on with the effort to reform our procurement law. Thank you very much, Madam Speaker.
Oh, I thought you were going to make a motion to place the Vice Speaker's third co-sponsor.
Oh, yes, Madam Speaker. I would like to have the add as a third co-sponsor Vice Speaker B.J. Cruz.
On that amendment, no objection. So on the motion to send 224-32 to the third reading file without any objection, so ordered. Senator Respicio.
Thank you very much, Madam Speaker. Madam Speaker, notwithstanding the House rules, may I make a motion to revert back to motions?
No objections, so ordered.
Madam Speaker, on the matter of Bill 306-32, introduced by Senator Uggan, an act to appropriate funds to the Office of Veterans Affairs for the implementation of the Guam Veterans Registry as mandated in Public Law 32-101. There was an amendment that was made and the bill was placed in the third reading file. The sponsor would like reconsideration to take further action that would be more consistent in line with what he wants to do. So I move that we take Bill 306-32 from the third reading file and place it in the top of the second reading file.
On that motion, no objections, so ordered.
Madam Speaker, I move that we, what's the title of the bill? I move that we, having had a committee report now for Bill 419-32 introduced by Vice Speaker Cruz, an act to amend Section 2, Part 1, Chapter 2 of Public Law 32-108 relative to authorizing funding for charter schools. I move that this be placed in the second reading file, numerical order.
Second reading file, not the third? I mean, we have 3 sections.
No, we still need to hear, this is a new bill, to place on the second reading file on the agenda.
You're right, but
Yeah.
is it on the third tier is what I'm saying? Because we have the first tier, second tier, and third tier.
Just numerical order, wherever it falls.
Yeah, you're right. It might fall on the second tier because we have 405 and 412, 402. So then there's the third tier. Okay, wait.
Okay.
So which tier is what I'm saying?
Well, my motion was numerical order, but if it's better to place it on the
No,
third.
but each tier has
Yeah.
it in numerical order. Remember, that was the discussion.
Okay, on the third,
in
on the
your
third,
CR.
I see what you're saying. On
Okay.
the third tier, yeah.
Okay, so it's in the third tier in numerical order.
Okay.
Okay, on that amendment, no objections to order.
Thank you, Madam Speaker. I have no motions, but I can move some legislative concurrences into the voting file. So I move that, notwithstanding the House rules, I move that we revert to item 14 of the session agenda under legislative concurrence.
Okay, on that motion, no objections to order.
Thank you, Madam Speaker. We have committee reports for item 1 from your Committee on Education, Public Library, and Women's Affairs on the nomination of Dr. Rosario to serve as guidance counselor member of the Guam Commission for Educator Certification, as well as item 2 from your committee for Dr. Michelle Santos to serve as a committee-at-large member of the same commission. With your committee's recommendation to do confirm, I move that be placed in the voting file.
No objections to order.
And we have committee reports from Senator Nicholas's Committee on Aviation, Ground Transportation, Regulatory Concerns, and Future Generations on the nomination of Christopher Murphy to serve as a member of the Real Estate Commission, as well as item 7 from the same committee on the nomination of Odessa Martinez to the same commission, Real Estate Commission, as well as item 8 from the same committee on the nomination of Joseph Stadler to serve as a member of the Real Estate Commission, with Senator Nicholas's committee's recommendation for all 3 committee reports showing to do confirm. I move this be placed in the voting file.
You also have number 9.
Sorry. Yeah, number 9, Marcel Camacho from the same committee with the same recommendation.
Okay, that's for
Okay.
the
Yeah.
member of the Real Estate Commission. No
Yeah.
objections to order.
And then the last 2 items 10 and 11 from the same committee on the nomination of Renny Lanata to serve as a member of the ABC Alcoholic Beverage Control Board, as well as Belinda Mejia, right, to serve as a member of the Alcoholic Beverage Control Board, also with Senator Nicholas's committee's recommendation to do confirm. I move that they be placed in the voting file.
Hearing no objections to order.
And Madam Speaker, notwithstanding the House rules, I move that we revert back to the second reading file.
Okay, so we're back on the second reading. No objections to order. We're also going to recess until tomorrow morning at 9. See you tomorrow morning.